So my name is Linda Wong. My co-host Penny Lopez. I think she's either here or wherever on your screen. She's my co-host here, and she's also a parent with FSI as well. Before we begin, we'd like to recognize and acknowledge that today we are meeting on the traditional and unceded territories of the First Nations. I personally acknowledge that I'm coming to you virtually on a traditional and unceded territory of the Coast Salish people, including Musqueam, Kwantlen, and First Nations. Our session today, we will end at 8 o'clock, maybe before that, depending on how many questions we might have. Please be reminded that all conversations are private and confidential. Support is non-judgmental, respectful, and differing opinions, and these meetings are a safe place. All Zoom security measures available have been put into place to allow for a secure meeting. If you have any questions, you can jot them down in the chat, and then Ken and Audrey will address them at the end of the meeting. We'll also make sure that we jot the questions down to make sure that they are answered. If you can, please keep your audio muted and your camera on. If you don't want to keep your camera on, that's okay too. Just a little bit of an introduction to what FSI does. So Family Service Institute is a provincial nonprofit organization which provides support to families and individuals with disabilities, diagnosed or not. Through a volunteer peer mentor model, these volunteers are referred to as resource parents, RPs, and resource family members, RFMs, and are located throughout the province. All RPs, RFMs, and FSI staff have a family member with a disability, diagnosed or not. Our volunteer parents provide emotional support, share their expertise and experiences, help families research and access resources, assist families to navigate systems, participate and support family during meetings, educate, mentor, and train families, and so much more than that. So I'm going to hand the following time to Audrey and Ken, and they will begin.
Thanks so much, Linda. I believe Ken is here as well. Let me just see if
I am here, Audrey, yes.
Oh, perfect. So I am actually going to let Ken introduce himself and his very impressive resume.
So good evening, everyone, and thank you, Linda and Penny and FSI and the families from FSI. We are really honored, Audrey and I, to be here once again tonight to present to this great group of families. And for some of you, you may have attended prior workshops that we've done with FSI or with other organizations, whether that be PLAN or the Down Syndrome Foundation, BOCCI, to just name a few. And so this is going to be the first of two sessions that we're going to do for FSI. Tonight, we're going to focus on wills and estates planning. And in March, we will also focus on personal planning and representation agreements. We've been working in this area for many years. Our firm is dedicated to estates and trust planning. We are a boutique. We don't do anything else other than estates and trust work. And over the years, we've developed obviously an expertise in assisting and supporting families navigate estate planning where they have a loved one, a family member with a disability. And so many of you tonight here are parents and you have a son or a daughter or a relative or a friend, and you're looking hopefully to learn a little bit more about estate planning with really a disability focus. I'm not going to run into my background. It's up there, but I would love to introduce you to my amazing associate, Audrey Junn, who has been joining me on a number of these sessions over the last couple of years. And Audrey is also someone that's an amazingly dedicated individual, committed to community, but also an excellent lawyer and practicing in this area of estates and trusts. And maybe Audrey, I'll let you say a few words.
Thanks, Ken. I mean, I don't really have too much to add to that. I've been working with Ken for the past, I think, almost 5 years now, and it's been a real pleasure and honor to work with so many amazing families who have done so much for their family members and friends, and who really have a strong connection to others in the community. So that's been great, and I'm looking forward to presenting today. And as Linda and Penny have said, we're really happy to take questions. Hopefully we'll answer most of them throughout the presentation, but if there's anything lingering after, we'll hang around and try to answer those as best as we can.
Yeah, in that regard, I mean, we always find that the questions are typically the highlights of these presentations. We always enjoy the questions, and it never ceases to amaze. Every presentation, we get great questions from family members. So I find that's really the highlight for us. That being said, we also appreciate that not everyone has the same level of understanding in this area, and we want to respect that. So what we'd like to do is run through the presentation, and that way we can leave, ample time for questions at the end, and for those that need to move on to other more exciting events tonight, they can do that. But we find that, through the presentation, we generally anticipate questions as well in the context of this presentation. But we also know that there may be others that we don't have coverage of. And so we'll politely ask you to maybe hold on to those questions as we go through this presentation. So the outline for tonight's discussion really is on, again, sort of disability and trust, from that perspective. And obviously, for many, many families, aside from the many other reasons why a trust might be important, one of the major reasons why we start the planning is that our child, our son or daughter, may be turning 18 and is now eligible for provincial disability benefits in British Columbia. So we want to sort of outline the importance of that. We also want to talk about vehicles, and this is really the crux of the presentation, is to talk about some of the tools that we have in estate and trust planning for people with disabilities. One of the other areas that usually canvasses a lot of interest and discussion is around the issue of choosing a trustee. I could probably speak all night about that. I won't. We'll touch on that issue because trusts are really important, but as are the choice of trustees. And then, we'll also touch on sort of other planning tools that may be available outside of the traditional trusts. We're in an age where, from a planning perspective with respect to disability, it's never been a better time to have a number of different resources that we have. So we have a number of planning tools in addition to estates and trust planning that we want to consider. And then finally, we'll leave you with some resources, more reading materials, more information, more guidance to help you on your journey as you undertake your estate planning. So for many folks, again, we generally start to assess estate planning generally because at the age of 18, our son or daughter may now qualify for provincial disability assistance from the Ministry of Social Development and Poverty Reduction. And in order to be eligible for those benefits, you need to meet certain financial criteria. And I'll give a real high level sort of overview of what that criteria is. And really, it's related to what are the asset limitations, what are the income limitations. And ultimately, again, very high level overview, if you're receiving provincial disability benefits, you are allowed to hold up to $100,000 in liquid assets. And that can be a bank account, can be an investment, anything that's liquid. You can own your own motor vehicle, and you can own your own principal residence. And the value of that residence is not material. It can be $100,000. It can be $2 million. It would be exempt if it is, in fact, your principal residence. Now, the whole issue of home ownership is another big topic. And obviously, we've also done some sessions for FSI on this topic, and we'll be doing something later in the year as well as part of your training weekend. But I would say that, you know, although a principal residence is in fact exempt, that doesn't mean you should run out and purchase a home or put the property in your son or daughter's name. There's a number of issues and questions that arise, obviously with respect to capacity to manage a property and issues that may arise thereafter. So, you know, the intention here is to highlight some basic exempt assets, but also why estate planning is so important. And so obviously having a will is one way to be prepared. Not having a will ultimately results in an element of unpreparedness. And, you know, we always think it's important to highlight some of the consequences of dying without a will. When we know that many families here, you're already ahead of the curve of the country. You know, only about 48% of our Canadian population has a will, which is scary. But we also know that families with children with disabilities generally are more geared to getting their estate planning in place because they have a higher duty, one might add, in terms of being prepared. But for those that don't have a will, I think it's important to highlight some of the consequences of not having a will if you die in British Columbia. And so, you know, one of the big challenges is that, you know, under this sort of what we call an intestacy, you die without a will, your estate is now subject to our Wills, Estates and Succession Act, or the acronym is WESA, W-E-S-A, which will ultimately determine how your estate is distributed. And not only that, but it will also determine who is appointed as your administrator. So you end up eliminating elements of choice. You now rely on legislation that is developed by effectively government leaders or MLAs, not necessarily what you want in terms of your estate. And this can be really problematic, especially in the Lower Mainland, and perhaps even nowadays throughout the province. As you know, most estates are generally going to be worth more than $100,000. And so not having a will could have some serious consequences for a beneficiary who is receiving provincial disability benefits. The other big challenge as well is that if you have minor children, allow the appointment generally in a will of a guardian. So if you don't have a will, then you risk that prospectively, either the Ministry of Children and Families may take on custody of your minor children, or your estate, i.e. the amount that would have been dedicated to your children, would be managed by the public guardian and trustee. So two separate government entities that may actually end up taking on responsibility for managing the affairs of your minor children. So Audrey and I, as well as I know our leaders at FSI, are very much of the opinion that families know better what's best for their children, not the Ministry of Children, not the public guardian and trustee. And I should add that those appointments or those prospective appointments of those two government entities is not done freely either. They do it with a fee, and that fee would come from your estate. And a lot of people don't realize that and think that as a last resort, that's the right option. But the reality is the fees of these entities can actually be much higher than even a private bank. So this is, again, more reason to develop a will. So the good news is that, trust is a vehicle within our wills to sort of plan for that person with a disability. And, what it does achieve is some element of certainty. You're not subject to the whims of legislation or government entities. And, the trusts are a very effective vehicle that, provide a lot of flexibility in planning for individuals with disabilities. And, not only is there the ability to now preserve provincial disability benefits, which is usually a major criteria, I find this other criteria of sort of providing oversight and protection to an individual that may not be able to manage money for themselves, either due to incapacity issues or because that person with a disability may have a higher level of susceptibility. So you've got these sort of inherent protections that can enable you to fulfill your duty to your family and that person with a disability and still have control and not rely on other third parties. So there's a number of really positive elements there that I think will, provide some confidence and ultimately control for families. I'm going to turn things over to Audrey to just touch on sort of some issues around wills.
Thanks, Ken. So Ken talked about, some obvious downsides of not having a will, and here are some really key positives of actually going through the process of developing a will. So initially, again, with a will, you can appoint who you want to manage your affairs in your estate after you pass away. You likely have somebody responsible in mind, or if you don't have any particular people in mind, you also have the option of appointing corporate trustees or professionals who essentially do this type of work as their main bread and butter. And so they'll have that expertise to be able to administer your estate and even look over any trusts that are within your will. In addition, if you have minor children, and I saw in the chat that many of you do have children who are minors, you will be able to appoint guardians, multiple or one guardian and an alternates for any young children that you have. In addition, obviously, one benefit that we're all aware of is that you're able to distribute your estate and the amounts into the people that you wish. And there is a little bit of a caveat on that that we'll go into later in the presentation. And of course, as Ken talked about, there's many benefits to setting up trusts, especially for people who are receiving PWD and who may not be able to manage those funds on their own. And many people do have a little bit of confusion. They hear about setting up a trust. They think they have to do it, while they're alive. But the most common scenario we see, and that's not to say this has to be what you do, but the most common scenario that we see is parents set up a will within their, or set up a trust within their will, so that once both of them pass away, or if you're a single parent, once you pass away, a trust is then set up for the benefit of your child with a disability. So it doesn't really come into existence until you pass away. So there's an option to set up a trust or even multiple trusts to protect certain beneficiaries. And when I talked about that caveat before in regards to distributing your estate and the amounts into the persons that you wish, what I was referring to is this concept of wills variation. Now, you might not have heard the term wills variation. That's more of a legal term that we use, but you might have heard of challenging a will or contesting a will, and that's what wills variation really refers to. So in BC, and this is not necessarily true in all jurisdictions, but in BC currently, there is seen to be a legal and moral obligation to provide for your spouse and children. So if your will doesn't provide for your spouse and children, let's say you have an estranged child, or you just decide to cut one of these individuals out, these individuals have the ability to challenge your will in court through a wills variation claim. So that's something that not everybody is aware of. That's not to say that you can never, I guess, go through with a plan where you leave one of these individuals out, but it is something to be aware of when you are doing your planning. So, in the past, I guess people may have commonly done something such as the following. So they might say, oh, my disabled child, they can't manage this money, so I'm just going to leave it to my sister, and my sister will take care of the child. So it's something really informal, and essentially you've disinherited the disabled child. Um, the thing with that is that if you leave them nothing, or you leave them a reduced amount in your will, the court can vary that your will, which means they would change essentially what your plan was and order that they receive a larger share of your estate. And that challenge may not actually be brought by that child themselves, but the public guardian and trustee of BC. And the reason for that is when somebody is probating your will, so essentially proving that your will is the valid will, the valid last will that you made in court, and there is a beneficiary who, has a disability, they do have this duty to notify the public guardian and trustee, who will review the will and review the terms of the will. And if they see that, you left almost nothing to your disabled child, they may actually contest that will in court on their behalf. So why a disability trust? Ken already kind of touched upon this and alluded to this, but one of the benefits for a disability trust, where you have a trustee appointed who does have that discretion to kind of provide for the needs of the principal beneficiary, is that those funds are actually not treated as the asset of the person receiving disability assistance. So even if there are millions of dollars within this trust, those are not considered assets that would disqualify the beneficiary from receiving PWD. They would continue to qualify for that assistance. And the reason for that being is that they're not really seen as having control over those funds, because it's really actually the trustee who does have control over those funds and has the discretion to make those decisions. And so in that way, trusts are a really great way for PWD clients and their families to transfer, safeguard assets for meeting disability-related costs now and in the future, and also those benefits, obviously, of helping them manage their funds if they're unable to do so, while also protecting them against undue influence from others, any vulnerabilities they might have that others may try to exploit in the future. All right, so we've been talking a lot about trusts throughout this presentation, and we often get a question, what is a trust really? I hear this word a lot, and it can be a little bit of a tricky concept to get your mind wrapped around. So, really briefly, and this is very simplified, there are lots of different types of trusts, but in general, it comes down to a relationship between three parties. So there is a person, the settlor, um, who essentially gives funds or certain assets to another person called the trustee, and that trustee has to hold it and use it for the benefit of somebody else, not themselves. And the person it's supposed to be for the benefit of is the third person, the beneficiary. So you can kind of see when somebody's making a will where they fall into these three categories. So you have often a parent appointing a trustee to hold and use funds for the benefit of their son or daughter. And again, I mentioned there are various types of trust vehicles. I talked briefly about testamentary trusts, which are created in a will and not really created until after the will maker passes away. And so I guess another way to call them would be death trusts. There are also trusts that you can set up while you're alive. So those would be called inter vivos trusts or living trusts. And those are settled by somebody while they're alive for their own benefit or for someone else. So there's many different types of inter vivos trusts. For those that are 65 and older, joint partner trusts or alter ego trusts might be an option. I won't get into that because that could be its own presentation, but just to be aware that there are many different types of trusts, and the differences being, again, on how that trust was created and how the income in that trust is taxed. And again, trusts are treated as a separate taxpayer, and there are constantly new rules on how trusts are taxed coming in. So it is a very complex area. And when you appoint a trustee, that's also a consideration because it is a really, really tough job, especially for somebody who's not really familiar with trusts and how they function. I'm going to turn it now over to Ken to talk a bit about the types of trusts within the ministry's trust policy.
Thanks, Audrey. And yes, I think this sort of next section is where some families get a little bit confused, but we want to try to simplify it for you so you can understand about, the types of trust that the Ministry of Social Development and Poverty Reduction will consider and what it means to have these types of trusts. So some of you may have heard of a non-discretionary or a discretionary trust. And I'm going to spend a little time going through each of these concepts to help everyone understand the distinction. But if you can consider that, the real distinction in terms of these terms really is a focus on the power and control that the trustees have in managing the assets. That's at the heart of the distinction. So the non-discretionary trust is really a creature of ministry policy. And in a really brief overview, the trustee with these trusts generally does not have total authority over how the assets are managed by the beneficiary, as either that beneficiary, and generally we're talking about a beneficiary with a disability, had some input in the making of a decision, either because, again, they are a trustee or they originally contributed the assets to that trust. Now, again, the ministry considers these trusts to be exempt. So if you're receiving provincial benefits, and you'll remember at the very beginning, I outlined some of the exempt assets, i.e. $100,000, a home, a vehicle. Now you can add a non-discretionary trust to that list. Now, there are criteria and limits, though, with these types of trusts, in that the total capital that can be contributed to this trust must not exceed $200,000. Now, there is a provision in the legislation, though, that permits you to seek a higher exempt amount if you can demonstrate to the minister that your lifetime disability costs may be higher than a $200,000 amount. And that's something that's available. But I think that the important thing here is that these trusts are really intended to hold up to $200,000. Now, a common example where these trusts may be valuable may be in a situation where, for example, grandma did not attend this great session put on by FSI. She went to her lawyer and decided to leave $150,000 in a cash bequest to her granddaughter, who happened to be receiving provincial disability benefits. And so granddaughter now receives these funds and is in a bit of a panic because grandma has now passed away. There's no way to change the will. And so one way to accommodate that gift and still preserve those benefits is to now develop a trust sort of after the fact. After grandma's passed away, granddaughter can come to us and say, I'd like to create a non-discretionary trust to hold this $150,000. I don't want to lose my benefits. And I also want to be one of the trustees, as well as the only beneficiary. This would be the trust for the granddaughter. And then the other area where this trust may be useful is where, let's say there's a personal injury settlement from ICBC. And that may permit the creation of this trust, again, to hold those funds while not losing provincial benefits. Now, remember as well that these trusts also presume that the person with the disability has capacity to actually develop these trusts. So they need to be able to meet that test of understanding what a trust is, as well as the prospect that they might be a trustee. So could they perform that role? That may not work for everybody. And so it's just something to be aware of. Now, the other, I would say, more common trust is the traditional discretionary, or what they call in Ontario, a Henson trust. These trusts are fully discretionary with the ultimate power of distribution of both the income and capital of the trust in the hands of the trustee. So this is a situation where the disabled beneficiary will not be a trustee. They will simply be a beneficiary. And they will be subject to the discretion of the person or the trustee. So they won't have any control, but this trust will, again, so this is another exempt asset, permit the beneficiary to continue to receive provincial benefits while at the same time receiving benefits from the trust, albeit at the discretion of the trustee. Now, a big advantage of these trusts, which we don't have with the non-discretionary trust, is that there is no limit to the amount of money that can be held in such a trust. You can have millions of dollars in this trust, and if it is a true discretionary trust where the disabled beneficiary only has a beneficial interest in the assets in the trust or a right to the income, but they are now subject to that discretion of that trustee. This is your standard true discretionary trust. So there are trade-offs with this trust, and for many families that are creating their wills and they have children with a disability, knowing that assets may be significantly more than $100,000, and where there's an understanding that their son or daughter with a disability cannot manage assets in any case, this trust permits not only the protection against a loss of disability benefits, but it also provides that oversight and protection from undue influence and susceptibility. So we try to also, in distinguishing these different types of trusts, just try to raise awareness, to be aware of some issues in the design. And this is really more for you when you're interviewing a lawyer to help you design these trusts, and ensuring that you have some basic fundamentals of that trust that the lawyer should know about as well. And if they don't know, then you might need to go to another lawyer. So the first thing that we want to ensure is in place with a discretionary trust is that there needs to be a class of beneficiaries in addition to the disabled beneficiary, or we call this the ultimate beneficiary clause. So for example, if you set up a discretionary trust for your son or daughter with a disability, and then they pass away with funds remaining in that trust, we want to have another provision that says that those funds will go to another party, either another relative, a friend, a charity, whatever your wish is. And the advantage of that is there is an avoidance of a collapsing of the trust. And the ministry gets very concerned when a trust could be collapsible. And a collapsible trust is in a circumstance where the last surviving beneficiary is, and assuming they're of age, 19 or older, they could ask the trustee to collapse the trust and release all of the funds to the person with a disability, i.e. the beneficiary. But by having an ultimate beneficiary, you now reinforce the discretionary nature and you avoid a collapsible trust. And in the eyes of the ministry, any trust that is deemed discretionary that turns out to be collapsible is now considered a non-discretionary trust, and the asset limit now reduces to $200,000, which I outlined before. And that can be really serious if the estate value is significant, because you may now have hoped that you've created a discretionary trust, but now you actually have what we call a non-discretionary trust because that trust is now collapsible. So, moral of the story, when you're designing that trust for your son or daughter, make sure that you have an ultimate beneficiary named, okay? Now, the other element that's kind of related to this issue is, go back one slide, please, is the issue of the even-handed principle. And so generally in trust law, there's a rule that says a trustee has a duty to provide income and capital to all beneficiaries. So not only your primary disabled beneficiary, but any of those ultimate beneficiaries. And so one of the concerns that trustees might have is, well, they want to provide for just that primary disabled beneficiary, which is generally the intention of many families. But because they attended this workshop, they remember, oh, yes, we need to have an ultimate beneficiary. And so one way to avoid this duty to this class of beneficiaries is to tell your executor, your trustee, that it's okay for you, trustee, to ignore this rule, this even-handed rule, and I would prefer that you just simply provide for my son or daughter with a disability, although I recognize that you have a duty to the ultimate beneficiary. So this clause alone can avoid a number of potential challenges. And so, two things to take away: ultimate beneficiary and the ability for your trustees to ignore the even-handed principle. So many families will ask, well, now that the trust is set up, so you've passed away, let's say, and your trustees are now managing the trust fund for a disabled beneficiary. There are a number of different types of expenditures that can be incurred from the trust with a really strong focus on sort of disability related costs. And you're going to see there's a list of potential areas here. We've got caregiver services, education or training, home renovations, home maintenance, medical aids. Now, for somebody that is receiving provincial disability benefits, some of these items may already be available to that person with a disability. So we want to be careful that our trustees are spending money out of the trust fund that are not being duplicated by government resources. So we always caution trustees, before you make an expenditure, perhaps you can determine, is this already something that that person with a disability is entitled to because of their disability benefit status? Outside of that, the other area of expenditure that's really evolved in the legislation over the last many years is this ability to provide for the person with a disability in order to promote their independence. And that's a really important clause because, the question is, well, what does independence mean? And quite frankly, it means whatever the trustee and the disabled beneficiary believe it is independence. The ministry does not question what you determine as independence. So it could be, tickets to a Vancouver Hockey Canucks game. It could be a trip to Mexico when we actually can all travel freely again. It could be a membership in a gym. It may be tickets to a movie, a dinner, etc. So there's a real broad category. I think the one thing that I just want to caution trustees on as well is that when you're making distributions, it is absolutely important not to distribute monies directly to the person with a disability. So you don't want to hand $500 to the disabled beneficiary. What you want to do is you want to provide for that person indirectly to third parties. So, for example, instead of giving the money, purchase the ticket for the trip to Mexico through a travel agent. Do it indirectly. Purchase the Canuck tickets directly with, the Canucks organization. Don't give the money to the person. And the fear of that is that the ministry will consider that money directly provided as unearned income. And any unearned income is actually deducted dollar for dollar for your benefits. So your trustee may have genuinely great concern for supporting a person with a disability, but by providing them with cash, they now have actually reduced the benefits, which is not the intention here. So, that's where we want to really understand that concept of unearned versus earned income and recognize that any income from a trust is considered unearned income and therefore deducted dollar for dollar from provincial benefits. And I think the importance here is that, although we hope that our trustees will do their diligence in understanding the interrelationship of disability benefits and trust law, we also know that, they may not have that expertise. So when they get in those situations, it may be prudent for them to get some advice before they start their mission, and have an opportunity, perhaps even to attend one of these sessions, and learn about the interrelationship of benefits and trust law. And that's a legitimate expenditure as well from the trust, to go out and get some legal advice so that you don't make mistakes. The other thing I should just highlight is that, the development of a trust in itself is not the end of the line here. When the trust actually comes into effect, and when I'm talking about a discretionary trust vis-a-vis your will, that trust generally won't be in place until you've died. And so you don't need to run out immediately and show that trust to the ministry. But when the person dies and the trust actually is now in motion, there is a duty on the disabled beneficiary who's receiving provincial benefits to have their trust not only submitted, but vetted by the ministry to confirm that it meets with their approval. So that's something that a lot of folks don't realize and they forget about. But there is this duty to have the ministry review the trust, again, when it is actually in place. And it doesn't mean it's in place when you sign your will. It means it's in place when you die. Or in the case of a non-discretionary trust, that's a living trust, more or less, when that trust is actually in place. Many folks ask about the types of assets that can be held in the trust, and generally there's really not a limitation other than perhaps registered investments. A lot of folks think about purchasing a property within a trust. I alluded to that topic earlier tonight, where the idea of home ownership is never been more complex when it comes to holding it in a trust. So if that's something that's being contemplated, I would again encourage really good legal advice before you undertake that initiative. I also mentioned that there are a number of other types of assets that we should also be cognizant of. And so, much of our focus is on estate planning and will planning and trust planning. But many, many times, individuals will have, life insurance policies, are RSPs and RIFs where they've designated a beneficiary. And it's important to recognize that when you designate a beneficiary, the will becomes a moot point. It's not relevant. The actual designated beneficiary receives that asset outright. So I've seen situations where clients have done all this great planning on their will and their trust, and then they go out and they designate their daughter with a disability as a beneficiary on their plan, not realizing that the will doesn't actually now receive that asset. And if the daughter doesn't have capacity to manage that asset, you now have a bit of a problem. So you need to be really cognizant of designations. And again, I would encourage legal and financial advice when you're undertaking those decisions. Okay, Audrey?
All right, thanks, Ken. So there are obviously many complex issues to consider when you're developing a trust. We'll go into one of the most complex ones after this slide, but a few that you should keep in mind is, initially, is the trust the best option available? Have you done a cost benefit analysis? Have you considered whether there might be other exempt assets that you should be considering or using? You'll also want to consider, obviously, the personal circumstances of the beneficiary. So when you're doing this planning with a lawyer, you're going to want to talk about what are their capacity issues. Are they married or are they single? Do you think they might have children or other dependents in the future? You want to get a good picture of, who is this trust for and what are the factors that we need to consider when we're developing this trust. And obviously, one of those things could also be the potential life expectancy of the disabled beneficiaries, what kind of assets they already might have that could affect whether a trust is necessary or not. But the most important and often the most difficult decision for people who are looking at developing a trust is choosing the trustee and any alternates as well. Um, and obviously, the reason for that is because they're kind of the crux and the heart of the trust. They're going to be managing the funds in the trust, and they will have a lot of responsibility, um, not only to manage the money, but also to do various administrative tasks, such as look at filing taxes and all of those sorts of things. So, when considering choosing a trustee, if it's going to be an individual, something to keep in mind is, how old is the beneficiary? How long will the trust last? It could last potentially, many, many years. Often with a trust where it's more less to do with a person with a disability and maybe it's a trust for some other reason. One big factor can be this 21-year deemed disposition rule, where every 21 years, the capital of the trust is deemed to be disposed of and any capital gains are taxed. Often, parents who are developing a trust for their child with a disability, that kind of becomes a secondary factor because it's primarily them recognizing that it likely has to be for the lifetime of the beneficiary and could last many years beyond 21 years because they will not be able to manage those funds after 21 years as well. So you could have this trust that lasts for many, many decades. So given that, how old are these potential trustees and alternates? The beneficiary could potentially outlive them, or those trustees might be very young and they might have changes to their living circumstances. They might get married, move away, um, be in a different country for work. So there's a lot of potential factors in there. And related to that, how many trustees do you want there? Do you want multiple trustees that could potentially give rise to conflict? Do we have to have provisions in the trust to deal with if there's a conflict between multiple trustees? And should there be provision for alternate trustees given that uncertainty around if you can place kind of all your eggs in one basket? and that one person that you appoint and you had in mind isn't able to do that job anymore. And of course, one thing that people always worry about is, I want to appoint somebody who knows me, who knows my family, who knows my circumstances, and who I trust, because I'm placing a lot of responsibility in their hands. So those are some questions that can come up. In addition, do you want to put some ability in there to remove, replace trustees, or give them the ability to resign? Um, there's all kinds of things you can do within a trust, and there's a lot more complexity um, in planning a trust than people sometimes initially think when they go ahead and say, okay, I want to undergo and go through this procedure of setting up a trust. Again, does that trustee have knowledge of the legislation related to disability in BC? Do they know, whether some expenditures from the trust could be considered unearned income? Are they aware of all those intricacies in ministry policy? So, on one hand, you might have a trustee who knows the beneficiary really well, but they might not have the specialized knowledge. Um, where does that intended trustee live? Sometimes you have family members who are in other countries, but one potential pitfall of that is that, and this has changed a little bit in recent years, but generally, where that trustee resides can affect the residency of the trust for tax purposes. So that's something to keep in mind as well. Another factor, how big is the trust? How complex is it? Is this trustee going to be able to manage that? Do they have the financial wherewithal to keep those funds invested prudently? What experience do they have with this type of thing? So a lot of these kind of go to also the question of avoiding conflict. Sometimes there is an inherent conflict where, for example, let's say you have three children, you have one child with a disability and two other children who don't have a disability. And often the parents are going to want to kind of appoint those siblings or, a close family member or friend to be the trustee. But sometimes those very individuals will be ultimate beneficiaries of those trusts. So eventually, if the primary beneficiary passes away, then they end up being receiving whatever's left. So there is an inherent conflict there. Um, Sometimes there isn't that type of conflict, but sometimes people are put into a position of conflict because they become essentially a money manager for their sibling or family member or friend. Whereas, otherwise they could have just had that ongoing normal relationship without this additional layer on top of acting as a trustee of that person's trust fund. And that's why some people want to explore this concept of corporate trustee or a professional who kind of does this, who is a third party, independent, doesn't really have a relationship with the beneficiary or other family members, but is kind of appointed in this professional role. And I did get a direct message from someone that kind of relates to this, where they say banks charge a lot of money to be trustees. What recommendations can you make for trustees? And so, yes, there are definitely, the big banks in Canada who all have sort of these trust roles that they can play. And again, they obviously have, what some people might consider to be high fees, but what they also have is some real expertise on how to manage trust funds. And depending on the size of the estate and the complexity of the trust, some people, when doing a cost benefit analysis, will decide, even though there are these fees, I'd like to go and appoint this trust company to act, or this financial institution to act as trustee of this trust. That being said, banks aren't the only option necessarily as a corporate trustee. There are smaller trust companies that are more regional and provide these services. There are a multitude of organizations, and as lawyers, we're not married to any particular trust company, depending on the estate. Um, we might make referrals to several different potential corporate trustees that may be appropriate for the situation. So it's kind of hard to give a blanket recommendation. And more than a recommendation, we generally recommend that people interview potential corporate trustees, get to know their services, their fee structures, what they provide, and, you know, just get a sense of which might be the best fit for you. Something to keep in mind is even if you appoint an individual like a family member or a friend, that doesn't mean that they're going to necessarily do that work for free. They can charge a fee as well. And if you go to the Trustee Act of BC, you'll see sort of kind of the maximums that they can charge as well. So, you know, even if you appoint an individual, you may be paying them a fee as well. And, sometimes if they don't know anything about trusts or they're not familiar with this process, um, they may be really inefficient as a trustee potentially. Whereas if you appoint a corporate trustee who has specialization in this area, they may introduce a lot of different efficiencies because they do this every day. So there's a lot of different factors to consider, and it will be, a decision that's up to you when you're balancing sort of what are the needs of the beneficiaries. Um, what am I looking for here? Do I have an appropriate person? Or do I not have an appropriate person? I might want to interview some corporate trustees. So there's a lot of issues to consider. It's not a really simple decision. And this is one of the things that most people end up spending kind of the majority of their time deliberating and debating before they finalize their planning. All right, so we did kind of talk about some of this beforehand, but we focus a lot on trusts because, it's a great tool. Many people find that that's what they need when they're doing their estate planning, but the trust is not the only way to preserve disability benefits. If you're thinking about preserving disability benefits, that's your key consideration. You do want to be aware of, again, those other exemptions. So $100,000, obviously, considering whether that person actually has the ability to manage that themselves. Again, that ability to purchase a principal residence or vehicle. And one really, great option as well that I don't want to forget about is the RDSP. So the Registered Disability Savings Plan. Um, Something to keep in mind is that not everyone is automatically eligible for the RDSP. They also do need the disability tax credit in order to become eligible for that, but they are able to um, get grants and bonds from the federal government if there are sort of contributions made to the RDSP, and there are great ways to kind of maximize those grants and bonds as well. And there are lots of great sessions put on by organizations in BC educating on the RDSP. So that is a really, really great plan to be aware of. There are also abilities to roll over funds from RSPs and RIFs, but that can be quite complex, so I won't go into too much detail on that. The point being is that you kind of want a big picture look at what are your goals, what are you trying to do here, what assets are there, what's the situation for yourself, your potential trustees, and your beneficiaries, and to always know that one size doesn't fit all. In order to get the proper advice, you're going to need to sit down with somebody who knows what they're doing, who's kind of aware of, the legislation, how disability works in BC, and the size of your state and the complexity of your state. So sometimes we get questions about what should I do in this scenario, and we can't answer not because we don't want to, but because depending on your situation and depending on the facts that we likely can't get from you without actually sitting down and talking with you for an hour or over an hour, we can't really give you kind of the right answer because it can really differ by situation. And to tie into that, you know, not all lawyers understand wills and trusts, and even if they do wills and trusts kind of exclusively, not all of those will understand disability issues. So sometimes we'll run into situations where, again, I think Ken touched upon this, you know, somebody has passed away, a grandparent, and they got their will done, and they thought they had done the right thing. They went to somebody that they trusted, who might be maybe a general practitioner or do non-disability related wills and trusts, but sometimes haven't done the right planning. And so then you kind of have to clean up the mess after the fact because they didn't take into consideration some of these issues. And they actually ended up creating kind of a large problem once they passed away because the proper planning wasn't done. So um, we will be sending out kind of a handout with the slides in a note format after the presentation. And you will have kind of a checklist of certain concepts that we've been talking about through this presentation, such as the even-handed rule, discretionary trusts, things like that, that you may want to use kind of as a checklist when you're screening a lawyer who you want to do your estate planning, to ask them how they'll be dealing with these different issues and to see if they understand and are aware of and are familiar with these concepts. Just some final words of advice. You know, when you're doing this planning, it's a big undertaking, but it is important to make sure that you have the necessary information, that you think about, you know, things that could happen in the future. So obviously you have to have a picture of how circumstances are now, but also be aware that things could change in the future and that you're kind of planning for all contingencies. When you are looking at appointing an individual as a trustee, you're obviously going to want to talk to them about it, see if they understand what kind of a responsibility it is, because it's not an honor, it's really a huge responsibility to be a trustee, and you want to make sure that they're actually going to want to become a trustee, because even if you appoint somebody, they don't necessarily have to act in that role. And again, you know, just making sure you're talking to a lawyer and an advisor who's experienced in this area and who has that knowledge of BC disability benefits legislation, and to ask questions, you know, be aware of what you're doing. You know, you don't want to go and kind of retain somebody and pay them and not actually get an understanding of what you're doing and why you're doing it, because this whole process is really about education as well. Ken, did you want to add any other final words of advice before we go into the resources?
Yeah, no, I think you've covered it really well, Audrey. I think, there's a lot of information here tonight, and I know for many families it can be a little bit overwhelming. And I think the important thing is to hopefully take some highlights from this, digest it, and hopefully you've now got a little bit more of a foundation of knowledge that you can use in your next stages, which is really the important element of choosing an advisor that will have expertise in this area. And I think the intention here of these presentations is to hopefully provide you with a little bit more knowledge and a little bit more insight as you undertake this sort of next step in your planning options. So we've left you with some resources as well. The Ministry of Social Development has a great information booklet on disability assistance and trusts. Highly encourage that reading material. Obviously, Family Support Institute, as you all know, is a great resource, and they have a wealth of information on their website. They also post these sessions, so you're able to actually view them again and again at your leisure. And I should add that in addition to, this session, they have a host of other amazing sessions. So, and I'm sure many families here are already really well aware of that. I would also encourage Planned Lifetime Advocacy Network, another group that Audrey and I regularly present for. And then, of course, our website as well. We have articles, webinars, information on estates and trust planning with a disability focus that I would encourage you to review. And again, the information hopefully will help further reinstill your knowledge in this area. So that completes our session, and we would be happy to answer questions. I can see that there's quite a few already developing in the chat. Linda, Penny, do you want to take that away?
Yeah. Go ahead, Linda.
Sorry. Yeah, I kind of jotted them down, so maybe we'll just go as we see them in the order. So the first question is, what happens to the trust if the child marries? And can a child with more capacity challenge the terms of a trust?
So maybe I'll take that one to start, if that's okay, Audrey. I think, the great thing about a trust is that it really provides you with a lot of control. And if you have not envisioned a partner, that partner will generally not necessarily be able to take with that trust, right? If the trust is intended for the person with a disability, and that person with a disability later marries, and again, just recognizing that we're not family law lawyers, we're estates and trust lawyers. But generally speaking, the trust is a great vehicle to be sort of utilized to sort of avoid uncertainty elements. And, that trust is really intended to plan for a primary beneficiary, which is the person with a disability. And generally, there may be a provision in there for a spouse. Let's say if the person with a disability passes away, maybe they're the ultimate beneficiary. But really, I think what the focus here should be on is, what does the trust say about the partner if there is a future partner? And then the second part of that question about the capacity to challenge a trust. So Audrey alluded to this in her presentation, the issue of will's variation. Anything that's in the will is open to will's variation, including a trust for a person with a disability. Capacity is relevant in terms of who might initiate that. So if the person doesn't have capacity, it's likely that the will and the trust is going to be reviewed by the public guardian. So they would provide that oversight about whether there is a need to challenge the will. And then if the person with a disability, let's say, has capacity, and let's say their sibling receives their share outright, and the person with a disability receives their share in a trust, the person with a disability might say, that doesn't sound fair. I would rather have my share outright. So yes, they have the ability to challenge that trust, but the hope is that your lawyer and you have articulated quite clearly why there's a need for a trust and that it's a legitimate reason, i.e., you're trying to preserve benefits, or number two, the person doesn't have a strong history of managing a large inheritance. So it's a very challenging question because, again, with any will, there's always the potential for will's variation if you have children or spouse. And I think the key, though, is to sort of be alive to the risks in the planning and to ensure that you're taking steps to actually sort of minimize those risks.
Okay, I hope that answered the question. The next question is, how often should a parent review their trust planning?
Do you want to try that, Audrey?
Sure. So, I mean, again, there's kind of no right or wrong answer for every situation. Um, you know, we have a system where we kind of ask families how often they want us to check in with them, whether that's every 1, 2, 3, or 5 years. We'd obviously recommend that once there's a large change in circumstances, like a death in the family, a marriage in the family, a birth in the family, those are all sorts of situations where you might think, oh, okay, maybe my planning has to be looked at again because circumstances have changed, like a trustee's passed away, or there's a new person that I might want to provide for in my will in a special way. Um, you know, there's all kinds of considerations. And I note that they mention their trust planning, but my sort of answer, I guess, applies to estate planning generally.
Okay, next question is, can the parent's life insurance proceeds bypass probate? So it goes directly to the absolute discretionary trust for the disabled child.
Yeah, that's a great question. And I think, I believe Robert is referring to the concept of a lifetime benefit trust. Now, generally, these lifetime benefit trusts are geared towards registered plans. And so life insurance is possibly going to fit within that category. I think that I would defer to some further research on that issue. My experience is generally it's a registered plan that permits the rollover into a lifetime benefit trust. Notwithstanding that, these are very complex transactions that generally require good sort of dialogue with the plan administrator, so that there's consistency, not only with the estate planning side, but with the plan administrator side. Audrey, did you want to add anything more to that question? I guess my sense is that the life insurance policy may not meet that criteria.
No, I didn't have anything to add. Thanks, Ken.
Yeah.
Okay, the next question is, can I place $500,000 in discretionary Hansen Trust and $200,000 in non-discretionary trust, so not to affect no clawback my daughter's PWD monthly pension?
Yeah, so I mean, I'd be a little bit curious, you know, what's the situation like? Why are you looking at setting up these trusts? Is this an inter vivos situation, or are you looking at this in your will? So there's a lot of, I guess, more questions that I would have about this scenario. But I think what you're getting at is that, yes, in a non-discretionary trust, you're kind of limited to that $200,000 before it'd be considered an asset. Whereas with a discretionary trust, because the trustee has that discretion, you don't really have a monetary limit on funds that can be there and still be considered exempt.
Okay, thank you. And then next question is, are there any lawyers who have a reduced rate to accommodate people on disability assistance?
Plan, which I reference in our resources, has a list of lawyers that provide this expertise. Again, I don't know what the rates are going to be, and rates are going to be all over the place in this area. And I know a lot of folks are, as most of us are, we're all focused on budgets. And I think that, what we try to encourage is that you ensure that when you're doing the plan, that you're actually getting the results you intend. And unfortunately, Audrey and I get to see wills that are done improperly and very economically. And the result is, unfortunately, a lot more cost than anyone ever imagined to correct that. How do you put a price on the loss of provincial benefits for that person with a disability? I mean, that alone may be $18,000 a year. So I think it's important to balance the cost, but also recognize that, the most expensive lawyer may not be the best lawyer, just like the cheapest lawyer may not give you the service you need. And that's why, I always emphasize, ensure that you're getting the results and the product that meets your family's needs. And absolutely, cost should be important, but you also need to get it done properly, because it could actually create significantly more costs. And Audrey and I have experienced this in the last year where, advice was given, economically, and it ended up costing, over $10,000 to rectify the deficiency. And that happens, unfortunately, more and more. But I would encourage Plan, and their website, Plan Institute, actually has a list of lawyers that families have utilized to advise on estates and trust planning. And, like any other investment, do your research, interview a number of lawyers before you feel that you've made a decision. It's a very big decision, and I think it's important to do your diligence.
Great, thank you. Regarding the 21-year trust taxation, is that taxed at the beneficiary tax bracket?
So maybe I can address kind of like taxation generally. And I just want to preface that by saying, we're not tax lawyers. That's actually quite a distinct specialty. But in general, as of 2016, all trusts are actually subject to tax at the highest marginal rate. There are a couple exemptions. And one of that is, I believe we touched on this, is the qualified disability trust.
Mm-hmm.
And in order for a trust to qualify as a QDT, it has to be testamentary, it has to be resident in Canada, and, the beneficiary has to qualify for that disability tax credit. And a beneficiary can only actually be eligible for one QDT. And so there are several requirements, but there are various things that go into it. But essentially, if they don't fall into this eligibility, it's likely going to be a trust that is subject at the highest marginal rate and not at that graduated rate. I don't know if you wanted to add anything to that, Ken.
Yeah, I mean, I think, years ago, we had a priority list. We talked about preservation of provincial benefits, and then we talked about protecting against vulnerability and susceptibility, using trusts, and then taxation kind of was that third on the list, right? And it's kind of like, what is the lesser of the evils? And, the reality, though, is that taxation is a relevant consideration in developing a trust. But for many families, I think we need to be cognizant of, well, what are our options? And, trust and tax law may be, a casualty of trust planning, in that you're preserving benefits and you have a disabled beneficiary that doesn't have the ability to manage money independently. So that trust becomes absolutely vital. And so, I think it's important to recognize the tax issues. And a good estate lawyer will also have that dialogue with you in designing your trust and ensuring that, we take into account some of these tax issues. And I think that's part of the overall plan here, is to make sure that families are fully understanding of what it means to have a trust, and what complexities that it adds to the person managing that trust.
Thank you. Next question. What's the difference between a trustee and an executor?
That's a great question, Lane. I see that. So generally, when we talk about executor, we're really talking about the person that is managing the will, managing your estate. So they when you pass away, they gather all your assets, and they pay all your bills. Very simplified oversight of that role, and then they distribute. The trustee is generally the person that manages the trust that you may have set up in your will. So the executor will do their job, and then they'll distribute assets. And one of the distributions might be provide a share to the trustee to be held for my disabled son or daughter. So those are the sort of two roles, very at a high level. Now, it is also possible for the executor and trustee to be the same individual, but it's not uncommon for that to happen. But they each have distinct roles from a legal perspective.
Great. Just due to time, we're not going to go through all the questions. I'm just going to pick through one other question that might be a little bit more important. What do you do if you don't have a guardian for an 18-year-old child and there's no other family? Is there any protections we can put in place?
Sorry, could you repeat the question, Linda? If there's no guardian at 18, what protections can we put in place?
Yeah, that's right.
I'm not sure, like, whose perspective are we asking it from? Like, I guess
think it's the parent that's saying that there's no other family that can be the guardianship for this child, and they're wondering if there's any protection, I guess, when the parents pass away.
Oh, I see. So the parents are trying to plan, but they don't have any prospective individuals as
Yeah.
the guardian.
Yeah.
But they'd like it not to default to the ministry and the PGT.
Sounds like it.
Okay, that's actually a really good question. Like, I actually personally haven't run into that before, so I'd have to think on that a little bit. I don't know if Ken's dealt with that situation before.
Well, and I think, I agree. It's a great question. I think the one thing to remember is that, although in a will, it's common to appoint a guardian, remember that appointment is not actually going to be fulfilled until there's a blessing of the court. So the appointment in the will is merely an expression of your wishes. And if you don't have a guardian appointed, then there is still a duty on someone to apply. So there needs to be someone that's willing to take on that guardianship role, whether it's a family member, a friend, but with the understanding that if no one does assume that role, that the last resort is, in fact, the ministry of children and families who would take on guardianship. And again, not being a family law lawyer here, I'm going to defer to the family law experts. My sense is that, that the ministry would at that point, obviously do what anyone would do. They would search for family, others that might be able to take on that responsibility. And failing that, they would then utilize the tools available to them within the ministry, which might result in, foster care, adoption. Again, that's a high level overview. And so, you know, I would caution that, you know, there would be a need for perhaps some family law advice in that regard. But generally, that's my understanding of how the things would evolve. And so it's important, I think, to have that dialogue today and think about it. And obviously, you know, many families are very isolated. They don't have folks that they can, you know, turn to in that role, which is understandable. And, you know, I think this is where groups like FSI as well can provide support and some ideas and resources to support families, and maybe, you know, through links with other families as well, just getting some knowledge on, I think, an issue that I'm sure crosses many parents' minds.
Great. Sorry, we won't be able to go through all the questions, but as Ken listed, there are resources that I'll be sending out in an email to everybody who's attended here. So we just want to thank KMK Law, Audrey and Ken for your time, for your presentation. And I know that this is such a relevant topic for so many of us, and there's a lot of questions, but unfortunately we won't be able to go through that in this session. It's been truly informative, and we thank you so much for your time. For all of our participants, there'll be a survey link that will be sent to you tomorrow, as well as the recording of this. So if you missed anything, you can always go back and listen to them. Audrey and Ken, do you have any closing comments?
Just want to thank everybody for your time. And I hope this information was beneficial. Again, special thanks to our great friends at FSI for allowing us to do this tonight.
Great. Thank you so much for attending, everyone. And thank you to my co-host Penny as well.
Good night, everybody, and thanks for attending. See you at the next session.